This video is for educational purposes only and does not constitute legal advice. Some content in this video was created with the assistance of AI.
Getting business records from a non-party can feel like hitting a brick wall. Miss a deadline, skip a notice, or serve the wrong address, and the custodian can refuse the documents, wasting time, money, and valuable evidence. In this video, I'll show how I handle a California business record subpoena, what forms I use when notices are required, and the timeline I follow to get records smoothly. You'll need 4 main forms: the deposition subpoena for production of business records, an attachment where you describe the records, usually labeled Attachment 3, the notice to consumer, and the proof of service by mail. These forms make up the core of your subpoena packet. At the top of the subpoena, fill in your name, address, phone number, and email. If you're an attorney, this section is straightforward. If you're self-represented, you'll list your own contact information here. Next, complete the court information: the name and address of the courthouse, the case title, listing the parties, and the case number. Now, enter the information for the custodian of records, the person or department who maintains the records you're requesting. Accuracy here is critical. Many subpoenas are denied simply because they were served at the wrong address. Always confirm the proper service address before you serve the subpoenas. Sometimes this means contacting the records department directly. Next, fill in the deposition officer information. If you're an attorney and haven't appointed someone else, you automatically act as the deposition officer. If you're using a subpoena service provider, they will be the deposition officer, and the records will be delivered directly to them. If you are self-represented, you must designate a deposition officer, such as a professional records subpoena service. Now, set the date and time for production. The consumer has 5 days to object if served personally, or 10 days if served by mail. The custodian of records must have at least 15 days after service to produce documents. To stay safe, I usually set the production date about 30 days from when I submit the notice to consumer for service. This covers the objection period and gives the witness enough time to respond. Select the method of production. In most cases, check the box 1A for delivery to the deposition officer. Here, describe the records being requested. In most cases, you'll reference an Attachment 3, which gives a detailed description. Don't forget to check the box that says Continued on Attachment 3. Finally, sign the subpoena. Attorneys can issue subpoenas directly. Self-represented parties must have the subpoena issued and stamped by the court clerk before serving it. Now, prepare Attachment 3. This is where you describe the records in detail, include the name of the person whose records are being requested, identifying details such as date of birth or social security number, the specific time period for the records. Because we are requesting medical records, we must also complete a notice to consumer or employee. First, fill out the top section with your attorney or self-represented party information. Next, enter the court and case details, the same information you used on the subpoena. Then, provide the name of the consumer whose records are being requested. For that, list who is requesting the records. In our example, it is the defendant. Next, specify the deadline for production of documents. Then, identify to whom the subpoena will be delivered. Finally, sign the notice just as you did with the subpoena. Next, complete your proof of service. In our example, we use a custom proof of service form, but you can use the standard judicial counsel form as well. Remember, the proof must show that the consumer was properly notified before the witness was served. Here is our completed package, which includes the notice to consumer, subpoena, attachment to subpoena, and proof of service. This is ready to go. Pack it to serve the consumer.
Welcome to Legal Insights Radio. Today, we have John Carter, CEO of Golden Gate Subpoena Services, here to talk about handling business record subpoenas in California. John, thank you for joining us.
Thank you, Karen. Happy to be here.
Let's start simple. What exactly is a business record subpoena?
A business record subpoena is a legal tool used to get records from non-party entities like banks, police departments, or companies that might have information relevant to a lawsuit.
Are all records treated the same?
Not quite. There's a distinction between regular business records and consumer or employee records. Consumer or employee records have extra privacy protections, so they require notices or authorizations and stricter timelines.
What forms are typically required for a standard business record subpoena?
For non-consumer employee records, you mainly need 3 forms: the deposition subpoena for production of business records, an attachment describing the records, and a proof of service by mail. For consumer or employee records, you also need the notice to consumer or employee and objection.
How long do you usually wait for a consumer or employee to object to a subpoena after being served with a notice?
Typically, you wait at least 10 days if mailed or 5 days if personally served before proceeding to serve the witness.
What happens if the consumer or employee wants to object to the subpoena?
A non-party consumer or employee can fill out the objection on the notice to consumer or employee and objection. If the consumer/employee is a party in the case, they must file a motion to quash in court.
Can the witness provide the records if the consumer or employee objects?
No. If an objection or motion to quash is filed, the witness cannot respond to the subpoena until the issue is resolved.
What options does the party requesting records have if the consumer or employee objects?
You can file a motion to compel production within 20 days of receiving the objection, or oppose a motion to quash if one has been filed.
How do you choose where and when the records are produced?
You pick a production date and hire a deposition officer, often a professional copy service. The records are usually delivered to them. For non-consumer records, the date should be at least 15 days away from service to allow the witness enough time. For consumer or employee records, the timeline is longer, usually 30 days, to allow for notices and objections.
Can anyone serve a subpoena, or does it have to be a lawyer?
Anyone over 18 who isn't a party to the case can serve it. If it's an organization, you can serve any officer, director, or custodian of records.
What exactly does a deposition officer do?
The deposition officer acts as a neutral party to receive records from the witness and ensure proper handling. They can also handle copying costs or deliver the documents to the party requesting them.
What about costs? Do witnesses get paid?
Yes, the witness is entitled to reasonable costs before providing records. This includes copying fees, clerical costs, postage, and retrieval services. If you inspect original documents on site, there's a small flat fee.
What happens if the witness ignores the subpoena or refuses to produce the records?
Then you may need to file a motion to compel in court. That's why following proper procedures and timelines is crucial.
Is there a way to avoid sending notices to consumers or employees?
Yes, if the person whose records you need signs a written authorization, you can skip sending the notice. That can save time, but it only works if the consumer or employee is willing to provide consent.
Are there common mistakes people make when serving subpoenas?
Absolutely. Some common issues include serving the wrong address and missing deadlines. Any of these can result in the witness refusing to produce records.
Finally, any tips for companies or individuals handling subpoenas for the first time?
Start early. Confirm addresses and double-check timelines. Keep copies of all forms and proofs of service. Careful planning prevents delays and ensures records are produced correctly.
Excellent tips. John, thank you for sharing your expertise.
My pleasure, Karen.
If you enjoyed this video, please like and subscribe. It helps us create more helpful content.